Very well. Good morning, everybody. My name is Judge Bonnie Rangel. I'm the judge of the 171st Judicial District Court. As everybody knows, can everybody be put on mute, please? Can everybody be put on mute because I'm getting out exterior noise? Very good. Thank you. I think it's yours, Mr. I think we've got exterior noise with you, Mr. Salazar. You may need to fix it because if you're going to be a witness, you better fix your outside noise, sir, because I think you've got some. It is 9:01 a.m., 7/20/2020. We are in the midst of a pandemic. Hello, in case anybody didn't know, the Texas Supreme Court has allowed us to handle hearings via Zoom and YouTube Live. And as everybody knows, we are on YouTube Live to comply the Texas Open Courts provision. You, Mr. Body, you, Mr. Saloom, if you object to proceeding via Zoom and YouTube Live, could you verbalize that right now if you object?
No objection, Your Honor.
Thank you.
No objection, Your Honor.
Very well. Thank you very much. If you need to utilize the options bar at the bottom, you can do that. Just ask my permission if you want to go into a chat room or you want to do a breakout room with your client or each attorneys. Just ask for my permission. I'll be more than happy to give it to you. I want you to know that Ms. Garza is my court reporter and she is participating in this hearing today. Obviously, we need a court record. And remember, no recording is to be done of this proceeding. The only court official record is the court reporter's record. Okay. Is Mr. Body, Mr. Saloom, is there either of you don't understand the instructions? Or you do understand all the instructions I've given you and you desire to proceed, Mr. Body or Mr. Saloom, both of you?
I understand, Your Honor, and ready to proceed.
Yes, Your Honor, I understand as well, ready to proceed.
Very well. Thank you very much. Let the record reflect that this is a TRO. I think this is your TRO, Mr. Saloom, correct?
Yes, Your Honor.
Very well. So you may proceed.
Yes, Judge. On the 2nd of this month, I filed this TRO and a suit for accounting on certain commercial property that the defendant has a secured lien upon. The plaintiff in this case, corporation, purchased the property back in April 2016. In 2019, September of last year, 2019. The plaintiff refinanced the loan with the defendant. In September, he encountered some financial hardship. Payments on that note were no longer made. And realizing this, the plaintiff contracted in January of this year to sell the property, Judge. And as you know, COVID has been a major disruption, and the contract, which I included in my application, was signed on the 28th of February. Closing was set to occur within 80 days of execution, thereby giving the plaintiff an opportunity to pay off the loan of the defendant and not lose his equity. COVID did prevent that. And at this time, there still is an active contract. There is an amendment to that contract. And I filed the TRO to prevent the foreclosure where the plaintiff would lose the contract, lose his equity in the property. He does have a $1.6 million offer to purchase the property and get the defendant paid off. And that's where we are, Your Honor, as far as a little bit of a background, Judge.
Very well, thank you. So what you want to do is just prevent them from foreclosing, allow you to sell the property, correct?
Yes, Your Honor, correct.
And that amendment to this contract in February, when is the alleged closing date now, if there's any?
August 28th, Your Honor.
Okay. What are the prospects of it closing then? We are still in the midst of this pandemic. What are the prospects, or what do you think, or what do you know?
It's hard to say, Your Honor. I mean, I understand that the prospective buyers are attempting to correctly get financing, or the alternative for an arrangement to be made between the plaintiff and prospective third-party buyers to convey it, to sell it. So it's hard to say what the prospects are. I mean, there's a feasibility period, et cetera, but I'm hopeful, and my client is hopeful he will be able to sell it, and more importantly, at this point, get the defendant paid what they're owed here.
When was the last payment made to the defendant? United Bank.
I believe it was September of last year. You're right. I could be wrong, but I believe it was September of last year.
But I thought, didn't they refinance it in September 2020?
No, Your Honor, they refinanced it.
I mean, 2019?
I believe they refinanced June 2019.
They refinanced it June 29th of 2019. They refinanced, right?
June 2019. I don't know the exact date.
Okay, June 2019. And then they stopped making payments September 2019.
Yes.
Is that correct?
Correct. As far as I understand, that is correct.
Okay. Okay. Okay, Mr. Body. You want to respond?
Yes, thank you, Judge. Marwan Bhatti on behalf of the United Bank, El Paso del Norte. Judge, we filed a response on Friday. Wasn't sure if you had an opportunity to review it, but I'll just kind of briefly summarize what it says. And then we had some exhibits, Judge. The gist of it, Judge, is this is it's over a $700,000 loan that was done on, the closing was on June 26, 2019. So this is all pre-coronavirus. As far as we know, there was no issues at that time. The borrower, which is a LLC, made two payments. And he made two payments in August, Judge. I think August 1st and August 30th. I've got the payment history, which I can, which I'll provide to the court here through my witness. But Judge, basically this company took out a $700,000 loan, made two payments, and immediately defaulted. And the bank has not been paid anything, Judge, since August of last year, 2019. We're talking about September, October, November, December, January through July. We're almost to August again. So it's almost been a year, Judge. And, you know, very understanding people are going through tough times with COVID. There's a lot of default and issues like that. But I just wanted to make it clear to the court that this was actually happening way before COVID, had nothing to do with it. And the bank was actually very patient, Your Honor. They waited. We actually originally were going to foreclose in January of 2020. And when we heard there was a contract, we obviously were interested in, we want it sold, and it's in everybody's interest. It costs less money in attorney's fees and less hassle. And nobody wants to be in litigation. So we let it play out, Judge. It didn't close for whatever reason. We actually kept in very good contact, the bank did, with Mr. Castillo, who's the owner of the plaintiff JIT Rental Limited Liability Corporation. We kept in good contact with him. And in fact, you'll hear some evidence from Mr. Salazar. We were actually approached by one of the buyers to assist with helping them finance to buy the property from JIT. So United Bank was willing to help other people come in and basically kind of take over. That has not closed. That application from Mr. Salazar, you'll hear that it didn't really take off the ground, Judge. So to our knowledge, there's nothing there. Having dealt with Mr. Castillo, the owner of the plaintiff's company, he's told us multiple times, it's going to be sold. I got a contract. But the last time we talked to the buyer, there was nothing there, Judge. I mean, we would love to see a sale. And, you know, practically speaking, it's actually too late for even the bank to post for foreclosure now for August. Because you entered the TRO, we took it off the table immediately that day. And so we had to do it 21 days before the first week of August. So August is automatically off the table no matter what happens today. The earliest that a foreclosure could happen is in September. And so, our position is, Judge, that it's a huge loan, $700,000, only 2 payments were made. This is a local community bank, Your Honor. It's not a massive Chase Bank or Wells Fargo. And the bank really tries to work well with customers. I represent them on several other cases. Very good bank. You've probably seen some of their commercials on TV. But the banks also hurt because they are trying to lend to people during this crisis. They have regulations from the FDIC, other national institutions, that they can only have so many actually bad loans on their books. And then they get in trouble on why are they not doing anything about it. And so we actually have to, unfortunately, sometimes litigate these things because we've got to protect the bank. And like I said, it's a community bank. Getting just a very quickly, I'll just go through the issues. I don't think they actually have a very good basis in this lawsuit for it. The TRO has been entered, but for a temporary injunction going forward until a trial. I can only assume, I'll guess from the court's docket, Your Honor, that you guys are very busy. You're going to be backed up because of the COVID issues. I believe you guys do a mixed criminal docket, if I'm not mistaken. And that's going to end up taking priority, I know, because if somebody's in jail, they're going to get a trial first over some civil case over money. And so, I know other courts are setting dates out. We're looking at fall, maybe summer 2021. So for the bank not to get any payments during this whole time, that hurts the bank. They are hurt, damaged by that. On top of that, Judge, number one thing on when you file for a temporary injunction and TRO is you've got to file a lawsuit, which they did against the bank. And their basis of the lawsuit, if you look at it, is it's a suit for an accounting. And they say, we want an accounting. Well, we've actually provided that. We just provided the loan history. And this one's a very easy. Sometimes, Judge, we've got years of payments and maybe banks screw up and they charge you too much interest. And, they take advantage of a borrower in some way that they wouldn't know. This is not that situation, Judge. This is actually one of the easiest ones I've seen. When I looked through the payment history, it was a loan was given, the guy made 2 payments, no more payments. So there's not much to account for. I mean, if he made extra payments, that's fine. But the guy, like anybody else, Your Honor, he has online access to his bank accounts. So he can just log right in and what's my loan? What's the balance? He gets monthly statements each month from the bank. So the suit for an accounting, there's nothing there, I think, on the underlying basis for the lawsuit. And when you file a TRO and try to get a temporary injunction, you have to show, the plaintiff has to show that he has a lawsuit, that we did something wrong. Tell us what United Bank did wrong and what we're guilty of. And there's just nothing there. And I think that since the underlying lawsuit fails, there can't be really a temporary injunction going forward because they've got to show that they've got a legal cause of action. One, they have a probable right to recovery sought. If they win, Judge, what would they win at a trial? And I couldn't answer that question. What would they actually win? Are they going to suffer irreparable harm in the absence of seeking monetary relief? If this problem can be fixed with money, if we were able to foreclose and the bank had done something wrong, but he can be compensated by money, then a temporary injunction is not appropriate because he can be compensated. He would just have to sue us. Well, as I mentioned, Judge, I mean, practically speaking, nothing's going to happen until September anyway, because we've already missed the deadlines to post. So if there is a closing in August, I think it can happen still, and we would gladly accept it. But I think a temporary injunction, if you enter it, it would be until a trial date. And that is just way too far and would hurt the bank. And the last point on that, Judge, is that they need to post a sufficient bond going forward now, because you already entered one on the TRO. There would be one on the temporary injunction. And that bond has to protect the United Bank in case they're wrong and we should win. How much United Bank should be compensated? And that one, Judge, in our response, we can put a number on it because the balance of the loan is approximately $761,000. So if he's wrong and they stop us for a year from foreclosing, that's what the bank is owed. The payments, Judge, just so for your own knowledge, they're about $6,000 a month on the principal and interest. So if you even counted about 12 months from August of last year to now, that's $72,000. And if you set a trial date, let's say another year out from now, next August, 2021, that'll be another 72,000. So we can put a number on it. United Bank would be damaged at minimum 140,000. And then the last point, Judge, is I wasn't sure if you're aware, and to the credit, I don't think plaintiff's counsel was aware either, but the same day that they filed their lawsuit last week I think on Tuesday, there was a property tax lender that also sued JIT, but it's not in your court. It's in the 327 district court. I think that's Judge Linda Chu, maybe. Judge Linda Chu. So there's another lawsuit, Judge, pending right now that says Ovation Services versus JIT and United Bank. They sued us because we're a lender, and they want to stop us also from foreclosing. So that's still pending. The answers haven't even been filed, but I attached that as an exhibit as well for today's hearing. And so Mr. Castillo had borrowed about $36,000 to pay his property taxes. Hasn't paid those guys either, the property tax lender. So they're suing to foreclose. So United Bank's also in danger that if those guys foreclose ahead of us, our loan would end up being wiped out on that lien. So we just know that the plaintiff, I'm sorry, has no ability to pay. And that bond needs to be set at an amount enough to protect the bank. And so I only have one witness, Your Honor, today, Mr. Salazar, who's the representative from United Bank. That's it for my opening. I appreciate it.
Very well, sir. Okay. Mr. Saloom, that was your opening. Mr. Saloom, do you have any witnesses?
No, Your Honor. I was told my client would join us on the Zoom hearing, but I guess he wasn't able to. But no, Your Honor, I do not have any witnesses at this time.
Very well. Okay. Now, Mr. Body, then call your first witness.
We would like to call Danielle Salazar from United Bank.
Very well. Daniel Salazar, can you please raise your right hand to be sworn? You solemnly swear the testimony you're about to give be the truth, whole truth, and with the truth, so help you God.
I do.
Very well. Thank you, sir. Go ahead, Mr. Body.
Thank you, Your Honor. And I've actually got some exhibits here, Your Honor. I emailed them to Ms. Becky on Friday afternoon. I can also share them on the screen if the court allows it.
Absolutely.
Okay.
Absolutely. That's probably better than Becky.
Yeah, it should make it easier.
Thank you, sir. Yes. Mr. Saloom, did you get them? Mr. Saloom, did you get the exhibits? You're on mute.
Yes, I did, Your Honor.
Okay. You still have to ask. I've not seen them. Before you share them, Mr. Body, may I remind you, you have to ask for their admission.
I'll do that, Your Honor.
Thank you, sir. Go ahead. You may proceed with Mr. Salazar. And I think we're getting the feedback from Mr. Salazar. Mr. Rick, right?
Yes, Judge, it is coming from Mr. Salazar.
Yeah. Mr. Salazar, I don't know. I think maybe you need headphones or you need ear pods. Do you have those?
No, ma'am, I do not.
Okay.
I apologize.
Okay, go ahead. Go ahead, Mr. Body.
Thank you, Your Honor. Mr. Salazar, would you please state your full name for the record?
Daniel Salazar.
You know, I actually froze there for a second, but did he answer the question?
Yes, he did.
Oh, okay. Okay, sorry.
He did.
Mr. Salazar, how are you employed?
I am a commercial lender with United Bank.
And how long have you been in that position, or how long have you been with United Bank?
I've been with the bank for 5 years.
Are you familiar with the dealings and transactions between United Bank and the plaintiff, JIT Rental Limited Liability Corporation?
Yes, sir.
Do you have personal knowledge of those dealings?
Yes, sir.
Do you have custody and control of the business records of United Bank?
Yes, sir.
Are you familiar with the company's practices for maintaining those records?
Yes, sir.
Now, can you explain to me the underlying loan on this transaction? What was the loan between United Bank and JIT Rental?
It was a real estate loan in the amount of $708,000. It was structured on a 5-year maturity based on a 20-year amortization. It was a refinancing of an existing note. It was with well.
And was it a secured loan?
Yes, sir. It was secured by a first lien deed of trust on 1850 Northwestern property in El Paso, Texas.
And that's commercial property on the west side, maybe?
That is correct.
Separately from this real estate loan, was there actually also another loan with the same borrower, same guarantors?
It was a different borrower, but it was the same guarantor, which were related to common ownership of Mr. Castillo.
Okay. And so how much was that other loan as well?
It was for $124,000.
And what was that loan for?
That loan was to refinance a revolving line of credit, and this loan was secured by vehicles in the company's name.
And what kind of business, if you could tell the judge in the court, what kind of business was JIT in? What were they doing?
They were in brokering and trucking industry.
And so that other loan, I'm sorry,
What does
Judge.
that mean? Brokering and trucking in, what does that mean?
They were contracted to transfer cargo. They
Oh,
had trucks and they would transfer cargo.
okay.
Sorry.
So basically they were in the trucking business?
Yes, sir.
And so there were several trucks and trailers that United Bank also had a lien over, is that correct?
That is correct.
And we won't, that's not part of this TRO, but is that loan also in default? Do you know?
Judge, I'm sorry to interrupt, but I need to object on the basis of relevance. I'm not sure how that loan is relevant to this proceeding, Your Honor.
What's the relevance, Mr. Body?
It'll explain, Judge, that the borrower, the guarantors that are all related in here are actually in default on several loans. And so there's no ability to repay the bank. And so, they're seeking an injunction moving forward, but we're showing there's no ability to pay.
Objection sustained.
I'll move on. So, Mr. Salazar, I'm going to now show you some exhibits. I'm going to try here with the court's permission here.
Absolutely.
Let's see if we
Fancy features.
can. I've never tried this on a live court hearing, Judge, so you might have to forgive me here. Figure it out.
Go to the bottom screen, share screen, the bottom of your options bar. Bottom of your options bar, it's green, share screen. Make sure you
Okay.
have your cursor, because once you put your cursor down there, the options bar appears.
Judge, it actually says host disabled participant screen sharing. I think you guys may have it locked on your side just for you.
I have one participant can share at one time. That's what I have. That's what I checked. One participant can share at one time.
Let's see. Yeah, it's when I press it, it says host disabled participant screen sharing.
Who can share? Okay, who can share? Who can start sharing? Who can also share? Okay, try that.
Oh, there we go. Yeah, there we go. Okay, let's see. Is that showing up for everyone?
Yes, sir. It says defendant, United Bank of El Paso, the Del Norte's temporary injunction hearing exhibits.
Okay.
There it is. Now, before you share, you want to ask for its admission, Mr. Body? One by one, or you're going to do the whole entirety? It's up to you.
We'll do that, Judge. United Bank would like to move for admission of exhibits 1 through 8, which were also filed with the response to the TRO temporary injunction.
Very well. Any objection?
No objection, Your Honor.
Very well. Defendants exhibits 1 through 8 will be admitted. Go ahead.
Thank you, Your Honor. Mr. Salazar, I've got defendant's exhibit number 1 pulled up. Can you explain to the court? And if anybody has a problem seeing this, I can even zoom in if that helps. There we go.
Very good. Yes, the judge is having a problem. That font is old judge.
No, I can't blame you, Judge. It's tough to look at things on a small screen. So,
That's better. That's better. Thank you.
Mr. Salazar, what are we looking at here? What is this agreement?
This is the commercial note that was executed on June 26, 2019. It makes a legally binding $708,000 note that's structured at a 7.5% rate for 5 years based on a 20-year amortization.
And is this is actually what they call a letter loan agreement?
That is correct.
Okay. And so paragraph 6, what does this paragraph 6 say, if you can basically paraphrase it to the court?
Basically, it's the events of default. It just outlines what the defaults are in the loan agreement, and it describes a cure period for the bank.
Okay.
And it describes
So
events. I'm sorry?
Oh, and we need to be very careful here, Daniel. I forgot, but the court reporter, she's taking everything down, so we got to make sure we don't talk over each other. But I'll ask you this: does it basically say 6A that if they fail to pay, it's a default? Is that correct?
That is correct.
Okay. And was this signed by the borrower?
That is correct, sir.
And it looks like the date of the loan was June 26, 2019?
That is correct.
And there were guarantors on this loan?
Yes, sir.
And who were the guarantors?
Mr. Castillo, who's the owner, JIT Cartage, which is a trucking company, and then JIT Logistics, which is a logistics company that he also owns. All 3 entities are related through common ownership of Mr. Castillo.
Okay. Defendant's exhibit number 2. What is this document, Mr. Salazar?
Number 2 is the promissory note. And this note, what it does is it outlines the terms of the note and the payments, as well as the late charges and the place of payment and the late fees.
And again, this promissory note recites the amount, $708,000, is that correct?
That is correct.
And can you tell the court, Mr. Salazar, what are the monthly payments under this note?
The monthly payments are $5,753.24 due every month on the 30th.
And it has the interest rate here on the promissory note?
Of 7.5%.
And is there some mention of security for payment in the note?
Yes, sir. There is mention of the note that it will be secured by a first lien deed of trust on real estate property located at 1850 Northwestern.
And is the legal description for that, and I'm paraphrasing this, is it Lot 1, Block 4, Westport, Unit 3?
Yes, sir. That is correct.
And did the borrower or the makers also sign this promissory note?
That is correct.
Mr. Salazar, can you explain to the court what is exhibit number 3?
Exhibit number 3 is a deed of trust. This is agreement between the lender and the borrower that they will real estate property in trust of a third party, which is usually a title company.
And so is this the document that gave a lien to United Bank over the property that was going to be secured?
That is correct.
And again, does it have the legal description as Lot 1, Block 4, Westport Unit 3?
Yes, sir.
And that is the same property as 1850 Northwestern Drive?
That is correct.
Sorry, I just overshot here just a little bit. Was this document also signed by the borrower?
Yes,
The deed
sir.
of trust?
Sorry. Yes, sir.
And you mentioned, excuse me, that there were some guarantees for this loan.
Yes, sir. That's correct.
And so what is exhibit number 4?
Exhibit number 4 are the guarantee agreements executed by Daniel Castillo and 2 other entities that were related, JIT Logistics and JIT Cartage.
And so Mr. Salazar, can you explain to the court, if the borrower doesn't pay, what is the guarantor's obligation?
The guarantors are obligated under this agreement to pay to support the debt through the life of the loan. And they're basically the secondary source of repayment if the borrower cannot fulfill its obligation.
And this agreement was signed by Mr. Castillo also on June 26, 2019?
That is correct.
And behind this guarantee agreement, you see another guarantee agreement by JIT Cartage Inc.
That is correct. Yes, sir.
And it appears to be an identical guarantee agreement,
That is correct.
also signed by JIT Cartage Inc. Is that correct?
Correct.
And then finally, there's the third guarantee agreement that appears to be from JIT Logistics. It says Texas Limited Liability Company. Is that correct?
That is correct.
And this was also signed and agreed to by JIT Logistics, Texas Limited Liability Company.
Yes, sir.
So, Mr. Salazar, I'm going to actually now skip ahead here to exhibit number 7. Can you explain to the court what is this exhibit?
Exhibit 7 is a pay history of the loan. It shows the outstanding balance and the day and the amount of payments were received.
So starting from the very start date, June 26, 2019, this shows that the loan started, this was the starting balance, $708,000. Is that correct?
That's correct.
And then it looks like, can you explain to the court, what is August 1st and August 30th, and what are these amounts?
August 1st was the first payment due in the amount of $5,753.24. When the bank received the payment, it applied principal and interest and reduced the outstanding balance to about $707,000.
And so then it appears that there was a payment made on August 1st and then on August 30th, same amounts. Is that correct?
That is correct. I'm sorry. The August 1st was for July payment, and then the August 30th was for the August payment.
Okay.
Same amount, and it reduced the principal amount.
Now, looking at this payment history, what does the rest of this show to the court from October through, I guess, through July right now?
Just late fees, and then legal fees for collections and notifications.
Does this statement reflect that any more payments were made since August 2019?
No, sir, it doesn't.
Now, there's a second page here. Can you explain to the court what is this loan payoff statement?
This is a payoff statement for the loan, good to July 17th. The total amount due is $761,220.42. It reflects the principal balance of about $706,000. Interest due from the last payment, which was in August 2019, up into July 17th, 2020, of $47,000. Late fees that have accumulated almost $3,000, and then legal fees that have been accumulated for attempted for collections of about $5,000.
So does this show that this $761,220.42, this number, is that the balance of the loan as of July 17th, 2020?
Yes, sir.
Okay. And there's a line for 1 day's interest. What is that?
Every day, the loans outstanding accumulates interest at a rate of $147.10. So that's what it reflects.
Okay. Now, can you explain to the court, I know this is a legal document here, but can you explain what this document is, this original petition?
Yes, sir. This is a legal documentation stating that a tax lender in the name of Ovation Services is suing for an outstanding tax loan in the amount of $36,000. And that they have a lien on the building, which is superior to United Bank.
Okay.
Sorry.
Does it tell you which court this is pending in at the very top? Top left?
The 327th District Court?
And do you see the filing date of this lawsuit in the top right where it says filed? Can you explain it
Yeah.
for what date?
June 18th, 2020.
And Mr. Salazar, how did you come to learn of this lawsuit, or when did you learn of it?
We learned of it, I don't recall, but last week, I believe, when the day before we were going to foreclose, we were notified of this tax lien.
And I believe that United Bank were they served with the lawsuit? Some process service served the bank?
Yes, sir, that is correct.
Okay. And you said that according to this lawsuit, that JIT owes approximately $36,000. Is that correct?
That is correct.
And if you can see here in the petition, do you see the line where it says that the defendant, which is JIT, entered a promissory note in favor of FGMS Holdings LLC?
Yes, sir.
And so the $36,000 number that you're coming with has it in this petition. Is that correct?
That is correct.
So it appears to be $36,034.57. Is that right?
Yes, sir.
And do you see that in paragraph 10 where they mentioned default by defendant JIT? Do you see that paragraph?
Yes, sir.
And does it reflect that, I guess, beginning November 30th, 2019, defendant failed to make payments under that agreement?
That is correct.
Now, I'm going to move back up to two final exhibits here. Exhibit number 5. This appears to be a letter from December 11th, 2019. Is that correct?
That is correct.
And did United Bank send out a notice of default and intent to accelerate on this loan that's in question in this lawsuit?
That is correct. Yes, sir.
And so did United Bank start the default process because it was not receiving payments in December 2019?
That is correct.
And at the time, was the default without acceleration, was it $24,375.94?
Yes, sir. That is correct.
Now, can you explain, Mr. Salazar, to the court, and this is just from your own personal knowledge, what was going on between Mr. Castillo and the bank in about December, January? And I'm referring to a sale of the property. Did you know anything about that? What can you tell the court about that?
Yes, at the time when we had a discussion with Mr. Castillo, he had informed us that his business was no longer operational and that he was in the process of liquidating his assets to get the bank current and paid off. He said he had listed his real estate property for sale at 1.6, and he had a potential buyer and was interested, and he was negotiating with them for sale.
Okay. Did United Bank at that time decide to give Mr. Castillo some time to make a sale happen?
Yes, we did. We elected to pass on a foreclosure in January, and we informed them that we would continue, but we would allow this sale, or we would allow more time for the sale to happen. But we emphasized to Mr. Castillo that he would need to get his work to get his current, and that the sale can't be his one and only deal, or only way to pay us back, because we weren't going to wait for a sale. We were going to allow just some time for it for the end of the month in January.
Now, were you aware at that time that the property taxes were also an issue with JIT?
Not at that time.
And he didn't mention that to you?
No, sir.
Okay. Now, at some point, United Bank decided to post this property for foreclosure. Is that correct?
That is correct.
Now, Exhibit 6 appears to be a letter dated June 15th that says notice of acceleration and substitute trustee sale. Is this basically when the United Bank posted the property for foreclosure?
That is correct.
And was the property set for foreclosure on July 7th, 2020?
That is correct. Yes, sir.
And I'm actually, Your Honor, I'm going to go ahead and take the exhibits down now. I'll stop sharing my screen if that's okay with the court.
Absolutely.
If I could just figure it out. Let's, oh, stop share. Here we go.
Yes.
Okay.
Top. You did a great job, Mr. Body, for the first time.
Thank you, Judge.
You did a good job.
You know, I actually kind of prefer this better because it's easier to follow along than in court, because sometimes there's a lot of people walking around. And
I agree. Zoom is fabulous. I don't know why judges are complaining and lawyers are complaining, and it's fabulous.
no, it's been great. You know, there's some good things that will come out of this, unfortunately. So, you know, one thing is that we're getting good on technology, and
We'll do more remote. We'll do more remote hearings.
exactly. So, Your Honor, I just had a few more questions for Mr. Salazar. Mr. Salazar, the plaintiff has sued the bank in this case for a declaratory judgment for an accounting. To your knowledge, did United Bank ever breach any of its obligations or duties to the borrower under the loan documents?
No, sir, they haven't, or they didn't.
To your knowledge, is there any allegation even from the borrower, Mr. Castillo, that his payments were applied incorrectly?
No, sir.
Is there any allegation that the balance on the loan is incorrect to your knowledge?
No, sir.
Did United Bank ever deny access to Mr. Castillo or the borrower to an accounting?
No, sir.
Does the borrower and Mr. Castillo receive monthly statements for the loan?
Yes, sir.
And do borrowers have online access to their loan accounts to see, look at their payment history, that sort of thing?
That is correct.
Mr. Salazar, if the bank is stopped for foreclosing today by the court, will United Bank be harmed by that?
Yes, sir.
And again, you had mentioned that there's also another party right now in the 327th that's trying to foreclose on the property at the same time. Is that correct?
That's correct.
If that lender is allowed to foreclose, would that harm United Bank's interests?
Yes, sir.
If there was a $500 bond in place going forward on this temporary injunction, would that protect United Bank's interests?
No, sir.
Now, if a foreclosure is placed on hold, will United Bank lose potential buyers that might come after a foreclosure?
Yes, sir.
if United Bank was allowed to foreclose, or I'm sorry, is not allowed to foreclose, is it losing on potential rental value of the property each month if it had the property in its name?
Yes, sir.
Is it possible that the value of the property could decline in the future until there's a trial?
Yes, sir.
Do you know currently if that property is still insured by Mr. Castillo? Is there property insurance?
Not that I'm aware of.
Do you know if he's been making payments on it or he's defaulted and on the insurance?
I haven't seen any proof. We haven't seen any proof of insurance.
And as part of the bank's loan documents, is Mr. Castillo required to keep the property insured?
That is correct.
Now, if the property, you know, God forbid, let's say it's a warehouse, is that right?
That is correct.
God forbid there's a fire or something and there's no insurance, would United Bank lose its interest by a potential emergency, you know, like a fire or something like that?
That is correct.
Okay. Now, could you tell the court what would United Bank's damages be if it was to prevail at trial? So let's say we move forward to a trial and we win. What is the amount that is owed to the bank that you can articulate to this court?
I believe about $743,000.
Okay. Do you think that if the bank enters a temporary injunction and a bond for the amount of the balance, and I think the balance as of this last July 17th was $761,222.42 per the payoff statement. Would that amount as a bond protect the bank going forward?
Yes, sir, it would.
And that does not also take into account the approximately $36,000 that is owed for the property taxes, correct?
That is correct.
So if you total that plus the 761, it's almost $800,000 is what would protect the bank in the worst case scenario if a foreclosure is blocked moving forward. Is that right?
That is correct.
Your Honor, I'll pass the witness.
Mr. Stone, questions, Mr. Witness?
Yes, Your Honor, just a couple questions to Mr. Salazar. Mr. Salazar, I'm going to refer to the plaintiff, JIT, as well as Mr. Castillo. When did he originally apply for an extension of credit with United?
For this loan, I believe?
Yes, yes, sir.
In June of 2019.
Okay, he applied the same month. Okay, what factors were considered in the extension of credit by United?
The cash flow of the business, the value of the collateral, and basically those were the two underlying factors.
Okay, there was an appraisal done?
There was an appraisal done, yes, sir.
And what did it appraise at, the building?
It appraised, I believe, at like maybe $865,000, if I recall correctly.
Okay. Back in June 2019, right?
Yes, sir.
Okay. I want to go back regarding the taxes and the maintenance of insurance. How does United typically ensure that property taxes are current and the building is insured during the loan process?
We're notified by the insurance carrier if the insurance is canceled, and once a year we request proof of insurance by the borrower. And for the taxes, the property taxes, we check starting in January of the following year to ensure that the property taxes have been paid.
So you checked January of 2020 as to whether the taxes were current for this property?
Well, for 2019, the taxes weren't due until January 2020. So for that loan, we checked for 2018 because the 2019 due.
When were you first made aware that taxes were outstanding?
I'm sorry, repeat the question?
When was United first aware that the property taxes were owed on this property?
When we got the legal notification from Ovation.
That was the first time?
Yes, sir.
Typically, does United, when taxes are owed, does United pay the outstanding amount and then add it to the principal of the loan? Or
No.
does it, how does it work?
No, sir, we do not escrow for property taxes. We follow through with the borrower to ensure that they make the payments themselves.
Is that for commercial and, I don't know if you know this, commercial and residential loans?
We don't, all we do is commercial loans, sir.
Oh, okay.
Not a residential, we're not licensed to do homestead loans.
Yes, sir. Okay, okay, thank you. You mentioned that Mr. Castillo had spoken to you before on a potential sale of the property. Is that correct?
That is correct.
Did you ever see the actual contract?
Yes, sir.
Okay, Your Honor, I'd like to, if I'm able to figure it out, share the pending contract that I had mentioned in my opening, Your Honor.
Yeah. I think it's still on. Who can share? All participants. You have the ability, sir. Go ahead.
I'm not sure if it's,
There it is.
oh, is it working?
Texas Realty Commercial Contract Improved Property.
Yes, ma'am. Mr. Salazar, is this, well, I know is this the contract that was presented to you?
Yes, sir.
Okay,
Now, this is an exhibit. You've not numbered it, I don't think, nor have you allowed its admit or requested its admission.
I apologize, Your Honor. I originally attached it as Exhibit B in my application for a temporary restraining order.
Yeah, but
I'd like-
this is a hearing. This is a hearing, so you want,
Yes, Your Honor, I move to admit this document as Plaintiff's Exhibit B or Exhibit 2.
Exhibit 2, what's 1? What's plaintiff's 1? You have
Well,
something-
I'm sorry, as Plaintiff's Exhibit 1, Your Honor.
Let us not be confusing. Any objection to P1?
Judge, I'll object based on lack of foundation. We don't have Mr. Castillo present to explain this contract. So I don't know if it's the most current one, if it's an older one. I think somebody has to actually offer it, based on their testimony into evidence through foundation. So that's my objection.
Objection to foundation is sustained.
Okay.
Lay the proper foundation if you can, Mr. Saloon.
Well, I just wanted to see if Mr. Salazar recognized this document as the contract that was presented to him by the plaintiff, Your Honor. Obviously, my client is not here to lay a foundation as to.
Do you recognize this document? Have you ever seen this document before, Mr. Salazar?
Yes, ma'am, that is correct.
You've seen it before?
Yes, ma'am.
Okay.
And you know what it is, Mr. Salazar?
It's a sales contract for the 1850 Northwestern property.
Okay.
He has some personal knowledge about it, Mr. Body, so I'm going to go ahead and allow its admission. Now, he may not have personal knowledge about certain provisions in it, but I'm going to go ahead and allow its admission. P1 is admitted. Now, Miss Anita, can we go off the record? It had just dawned on me, Miss Anita, how are you going to get these documents?
This is actually the first hearing that I've had where we've had exhibits.
I think what I'm going to tell these attorneys is to email you all these,
Okay.
right? Don't you think that's probably the best way to do it?
Yes, ma'am, that probably is.
Okay,
We can
okay.
do that, Your Honor. Not a
Yeah.
problem.
Please, Mr. Body, exhibits 1 through 8 and this one and any more you may have, please email them to my court reporter at, Miss Anita, your email.
It's A.N. Garza, Garza, at epcounty.com.
After the hearing is over, please. Okay. Back on P1, continue.
Yes, Mr. Salazar,
Yes, sir.
did you have a chance to review Plaintiff's Exhibit 1? Did you have a chance to review this?
At the time it was negotiated, or it was presented to me, yes, sir.
So you read through it and understood the terms, et cetera?
I believe so.
Okay,
Yes, sir.
so would you agree with me that on page 1, it's showing that a proposed sale price is 1.65 million for the property? Would you agree with that?
Yes, sir.
Okay. would you agree that the contract was contingent on third-party financing from the buyers, Mr. Salazar?
Yes, sir.
Just 1 second.
Mr. Salazar, I saw a $3,000 earnest money there that had to be deposited. Do you know if the $3,000 was deposited with Sierra?
I believe at the back of the contract, there's a copy of a check made to the escrow company, if this is the correct contract. But I did see a copy of a check.
Okay, so
That's pretty ridiculous. 1 million with only 3,000 earnest money?
It sounds pretty low. Yeah.
That's pretty ridiculous. Absolutely. Go ahead.
yes, Ryan. Mr. Salazar, did you review the portion of the contract that mentioned closing of this transaction?
I don't recall.
Okay, would you agree that, I mean, the plain language of the contract, that closing was set to occur within 80 days from execution of the contract?
I'm sorry, could you repeat the question?
Would you agree that per the contract, the closing was set to occur within 80 days from the execution of this contract that you had an opportunity to review?
Yes, sir.
Did Mr. Castillo mention any issues with closing based on the COVID pandemic?
No, sir.
He did not mention anything to you.
No, sir.
Did he mention anything as to why this transaction did not close within 80 days of execution?
He said he was waiting for the borrower to get financing.
Okay, do you have any knowledge as far as the borrowers soliciting your company to obtain financing?
He did.
And what happened with that?
We looked at the terms of the deal, and we needed proof of deposit for the down payment. If you recall, on the first page, there's a $300,000 down payment. She didn't have access to funds to make that down payment, so she was waiting to get funds for that so that we could finance the remaining portion, and that still hasn't happened.
Understood.
How do you know, Mr. Salazar, how do you know that still hasn't happened?
Because the last time I talked to the borrower, which was a couple of weeks ago, she said she was still
The
I'm
borrower.
sorry, the buyer.
That's the buyer. That's
I'm-
Campbell. Those are the Campbells, right?
Yes.
Correct.
And you spoke to her 2 weeks ago?
No, about maybe 3 weeks ago. And she said she was still looking to get financing from, or not financing, but those funds to make the down payment.
Okay.
And then she was also looking to get approval from the SBA to do the loan, because she, under the SBA, she has another SBA loan, and she's under a restrict covenant for no additional debt, and she was waiting to get a release from the SBA to go forward with this loan. So those were the two factors that were stopped or slowing down the loan process, or the loan proposal process.
Okay. You testified that the approximate payoff amount on the loan is more or less about 700,000 and some change, Mr. Salazar, is that correct?
That is correct.
Would you agree that if this transaction were to close, the plaintiff would have enough funds to not only pay off United, but pay off the tax lien in this scenario?
That is correct.
Would you agree that the plaintiff has sufficient sizable equity in the property based on the sales price of this contract?
That is correct.
Would you agree that if United is allowed to proceed and foreclose, he would lose all of the equity I just mentioned?
That is correct.
Okay. I'll pass the witness for now, Your Honor.
Very well. Any additional questions, Mr. Body? You want to unshare your screen?
Oh, yes, ma'am.
Mr. Saloon, thank you, sir.
Yes, ma'am.
At the top, stop sharing. Okay. Mr. Body, any questions? Redirect. Mr.
No
Salazar.
further questions, Your Honor.
Very well, okay. Thank you, Mr. Salazar. Any more witnesses, Mr. Body?
No further witnesses, Your Honor.
There you go. Okay. You want to give a brief closing, each of you?
Yes, Judge.
Go ahead. This is your motion, Mr. Saloom, so you may continue.
I-
Did Judge, I understand, before you continue, Judge Garcia issued out the temporary restraining order in this case. What was the bond that he set it at?
$500, Your Honor.
Okay. Go ahead. Okay, go ahead, Mr. 500 bucks.
Yes, Your Honor. Don't shoot the messenger, Judge. That was-
I know, okay.
Just quickly, Judge, just two quick points from the plaintiff. An accounting cause of action is recognized under Texas law. I understand that there are only a couple payments made on this loan, but it is a proper cause of action that the plaintiff did plead. I understand that, we would need some sort of trial on the merits to determine, what that would be. We do believe it has merit. But more importantly, Judge,
Why does it have merit if it was just the origination date was 2 months prior and only 2 payments were made within 30 days?
well,
Why
just,
does
I
it
mean,
merit?
well, I may not have the, obviously my client is not here to testify, but I'm just, letting the court know that it is a recognizable cause of action under.
It is, but I don't know if it has merit in this particular case, of course.
Yes, Your Honor.
2 payments were made to this bank. That's it. How can you ask them for an accounting? It's not a complicated thing. It wasn't for many, many years, like Mr. Body said.
Right, and I agree.
You know why you guys filed it?
Excuse me, Your Honor?
You know why you guys filed it?
Yes, Your Honor.
To stall. You had to do something to stall this foreclosure. You did a great job. That's what you did it for.
Thank you, Your Honor. But I mean, as was presented in the testimony, the plaintiff does have considerable equity in the property. I've explained to him it's imperative that he either pay the defendant off or make arrangements as soon as practical. He is hurting. The COVID pandemic, I know, has affected his business and his ability to repay, and he's not denying the fact that they're owed. I mean, that's plain and simple. It's obvious. What we're asking, Your Honor, is some more time so that his interest, his equity may not be diminished and him lose all past payments and his interest in the property, Your Honor. And it's also his business, his livelihood. So that's what the plaintiff would like the court to consider and be made aware of, Your Honor.
The problem with this case is really, this is the problem. Mr. Bonnie, I don't even know if you need to argue because I think I'm on your side a little bit. The problem with this case, Mr. Colum, is the fact that we've got a lawsuit where there's a tax lien that's superior over and above United Bank if we don't let United Bank move right now. That's the problem.
Honestly, I wasn't even aware of that suit until Mr. Body actually told me that. I mean,
Yeah, see, that's the problem we've
yes,
got.
Your Honor. Yes, Your
If
Honor.
we didn't have that tax lawsuit looming, right? If we didn't have that tax lawsuit looming, then I would say United Bank, be a little patient, wait a little bit. But I don't know what Judge Chu is going to do. And I don't know what the courts are going to do now. And a tax lien supersedes everything, everybody, everything. United Bank will be out of luck. Out of luck. That's the problem we have in this case.
I understood, Judge. I understand. That is an obligation Mr. Castillo must address and take care of. I agree, Judge. I don't.
Judge, I'm sorry to interrupt, but Mr. Body just sent a chat to everyone, says that his audio has gone out and he's gonna try to call.
How could his audio have gone out? How does that happen, Rick? Can you
I
tell?
have no idea.
Can you tell? Mr. Body, he did. I didn't get any chat from him.
Yeah, he sent a chat to everyone.
I'm sorry, Judge, my audio cut out. I'm going to try to call. I just read it. Thank you, Rick. How does that happen? Mr. Salom, are you technologically gifted?
Unfortunately, I'm really not, Your Honor.
But you're young, sir. You
I
should.
know, I have no excuse, but I'm technological.
You're not. Now, he had to have been working on the speakers on.
Enter your meeting ID followed by pound.
We can hear it now. I think that was Mr. Body.
You have not entered any numbers. Please
Mr.
re-enter
Body,
your
we can
meeting
hear
ID
you.
followed by pound.
Mr. Body, can you speak to me?
I don't believe he can hear you, Your Honor.
But we can hear him.
Yeah,
Tell
we-
him.
It's looking like we can hear him, but he cannot
Enter your
hear us.
participant ID followed by pound. Otherwise, just press pound to continue.
Okay. Why don't you tell him just to check back in, Rick? Get out
You
and
are in the meeting now. There are 7 participants in the meeting. You are muted. You can mute or unmute yourself by pressing *6. You are muted. You can mute yourself by pressing *6.
we're going to have lots of.
Hello, Judge. I'm sorry. My computer cut out and I was panicking over here.
Stop your computer. Go with your cell phone and get out.
Okay.
Okay. Mr.
Now he's showing that he's on mute.
Okay, Mr. Body. Let's unmute.
Yes, Judge, can you hear me?
There it is. I just unmuted you. Yeah, good. So you're just participating just with your phone, sir. And we don't have any video of you, so that's okay. It's all good. Can you hear me?
Okay. Yes, I can, Judge. Sorry, I started panicking there because my audio cut out and I could see you guys and I was like, I can't hear anything.
I
I
wonder
was panicking. Sorry.
And I'm glad Rick is there to kind of, he's vigilant with everything, chat and everything. Okay. Now, did you hear the part where I said the problem that I have is that a tax lien lawsuit is looming and United Bank
I
is,
didn't hear that part. I didn't hear that part, Judge, but yes,
I told him that's the
that's an
problem
issue.
I have in this case. Is if we don't do anything here to take care of United Bank, it's going to suffer irreparable harm because there's that tax lien lawsuit that supersedes everything. Everybody knows it. Then you lose control. Again, United Bank is at the
That's-
mercy of Ovation. Right?
That's absolutely correct, Judge.
Right,
That's a big problem.
That's the problem we see. Now, is there any way, a gentleman, and please tell me this is what I want to do. Can I grant him because you know what, Mr. Body? I think we can try this case in 2 months, 3 months. I think we can. This is it. This is it. And I don't know. Your client owes that money. I'm just feeling a bit of, he's got a lot of equity in there. Plaintiff's got equity.
Right.
And I just don't know if this contract's a very viable contract. If she can't even prove, the buyer can't even prove the $330,000 down payment. She can't prove that to anybody. I just don't know how viable this contract is either. But can I give a conditional temporary injunction for 3 months? Can I do this? But he has to pay the $36,000 lawsuit. He's got to pay it.
Yes, Your Honor.
And then he has to take out a bond for $761,220.42. And he'll have 3 months only. And I think that way, Mr. Body, United Bank will be protected, right?
Right.
And he'll have 3 months to make this deal go through. I just don't know if Mr. Castillo has the monies to pay this lawsuit off. And this lawsuit has to be paid off like in 24 hours for this conditional bond to be valid, I guess. Are there any hearings on that other, the tax lien? Does anybody know?
Not that I know of, Judge. I think we were served, I believe, on July 6th or 7th. So we haven't even filed an answer yet, which we'll end up filing this week. And so I don't think there's any hearings yet. But it is some kind of expedited property tax foreclosure thing that they've filed. It's got one of those funny cause numbers like 2020 DTX something. So it is meant to be expedited. But Judge, what you're actually proposing, I think we're fine with that. That sounds very fair.
I think it sounds very fair. It takes care of, it gives Mr. Castillo 3 months to hustle and bustle and move and shake and make it happen. Meanwhile, that $36,000 lien is taken care of, and the bond is set at 761,220.42. I don't think we need to add the 147.10 cents from July 17th to the present. Are you okay if we don't do that, Mr. Bobby? We're talking about $5.
That's fine, Judge. That's fine. We'll let those 147 go. If we have a bond for 761,000, we're more than happy.
So now that you've told me that, the answer date hasn't even lapsed yet, right?
Right.
Mr. Castillo has maybe, when is the answer date?
I believe the answer is due, let's see, 7/14, the 27th, let's see, Monday the 27th, Tuesday the 28th. It's Monday, July 27th, I believe is the answer. 1 week from now.
Okay.
Yeah.
Okay. So can we say that he has to pay it between 1 week from the answer date? Mr.
I think that's fine.
Right?
No objection to that. Yeah.
Are you okay with that?
So within 1 week of the answer date, Judge?
No, within 1 week of today's date, which is the answer date, next Monday.
Okay, Your Honor. So the 27th then.
Right?
Okay, Your Honor.
This pretty much cuts him off if he, he's not going to be able to contest anything. He's got to pay that money.
Yes,
If
Your Honor.
he could contest it, or he doesn't owe that money, or, I mean, I don't know. He's not going to be able to do that to get this TRO.
Okay, Your Honor. I understand.
Okay.
Yes, ma'am.
Okay. So somebody draft it then, please. Who's going to draft this conditional bond? It's really a conditional bond is what it is. Right?
I don't mind, but yes, Your Honor. And I don't mind drafting it, and I can circulate the draft to Mr. Saloom for his approval.
Right. And then we have 3 months. We're looking, right now it's July, August, September, October. I could hear this. There's not going to be one criminal case that's going to want to go to trial on Zoom, Mr. Body. So my civil cases, my civil cases are going to be given priority. Cases such as this, it's not that document intensive, not that document intensive, and that we can look at that. We did great. Except for my freezing of my internet a little bit and your audio difficulty, I think we did pretty darn good. Right? So
you're right, Judge, and it's actually a very simple trial. You pretty much saw the documents right now, so.
Absolutely, absolutely. So I think we can go in 3 months from today's date, and Becky will give you a date on it, and that's the end of the TRO, and that's it.
Understood, Judge.
And
that's fine, Your Honor.
And I think that's the fairest for both sides, really.
Your Honor, I'm hopeful my client can meet the conditions, which I believe are fair.
Right. I hope so too. I really think he's got a lot to lose.
Yes, he does, Your Honor.
And the other thing that doesn't give me too much compassion is he's been having financial difficulties since last September of 2019, pre-COVID. Pre-COVID, he's been having financial problems. If he had kept it up to date and paid, and then this deal didn't go through because of the COVID, he'd be in a much better position.
Right, Your Honor. I understand.
Right. So I think this is really a gift United Bank, Mr. Salazar, just be a little bit more patient. Hopefully this man can pull it off and get this money and he's gonna make a good chunk of money if he can sell it for 1.6 million. Holy moly. So let's give him 3 months to try to do it, to get you paid. It's only really a couple months more because you wouldn't be able to file foreclosure until September. You'd have to start all over again, right?
Right.
September. So we're really looking at an October trial date. So it's not too much longer either, Mr. Salazar. So please tell United Bank for another month or so. Okay? I tried to do it as fair as I could, trying to take care of everybody, and I think I did. And I'm glad I can do a conditional. I've never done a conditional TRO before. That's why I asked you if I could do it.
I think it's fine, Your Honor, because those conditions are part of any, injunction, temporary injunction. You can put the bond amount.
Right.
Yeah. So
Absolutely.
that's all within your discretion.
Well, I hope this has a happy ending and that your client can come up with this money so that Mr. Saloon, so that this TRO can get into effect. And I hope within the 3 months he can sell it and make that good little windfall of profit, and United Bank gets their money.
Thank you, Your Honor.
Very well. Anything else?
Thank you.
Anything else, Mr. Ball? Who's gonna prepare the order, the TRO?
I will, Judge Marwan. I'll prepare it and I will send it to Mr. Saloon to review for his approval, and then we'll just need a trial date from Miss Becky to insert into it.
Becky, can you give us a
And I
trial
think that's-
3 months from today's date? Oh, Miss Becky's not there.
Yeah, Judge, from when do you want the trial date? From when?
3 days from today's date. Let's do it on a Monday in 3 months. 8, 9, 10, 20. Can we do it about 10, 20, 10, 21?
That should work with me, Judge.
What's the date? What's the Monday about 10, 20, 10, 20? What's the date?
I think it's Monday, October 19th, Judge.
Okay, Ms. Becky,
He's not on, Judge. I'm writing it down.
ask Ms. Becky if we can do October the 19th, 9 o'clock.
Can you stand by and I could check with her real quick?
Absolutely. So Mr. Body can put it in the order and then we're done.
I'll do that, Your Honor.
And this
I've
is
got
setting
no
it for a Zoom trial, right?
Boom, absolutely.
Okay.
Well, if we're in person by October, great, it'll be in person. If
I
not,
hope so.
the back.
Okay, I'll tell her.
Yeah. I don't think we're gonna be having in-person hearings for a while, really. So I think it'll be Zoom, and I think we did a great job with Zoom. Mr. Salazar, were you comfortable with Zoom as a witness?
Yes, ma'am, I was. Thank you.
Did you feel you were limited in any way? This is really my first substantive hearing. I've been doing status conferences, admonishments, stuff like that, but never a hearing with exhibits and witnesses and all of that. Did you feel limited in any way at all, sir?
No, no, ma'am, I didn't. This went well.
Tell me. It
did.
went well?
I'm sorry?
It went well, you said.
Yes, it did. The audios were. And
Yeah, right. Your audio's coming in.
Judge, is it going to be a one-day trial?
Yes, one day, probably be 2
Okay.
hours.
All right, hang on.
2 hour, 3 hour max. Give them the whole day though.
Judge, is it not a bench trial, jury trial?
No bench.
Bench trial. Yeah.
Wait. Are you guys gonna give up your right to a jury trial?
Hang on, Becky.
Well, I'd have to discuss that with
With
my
your
client, Your Honor, but
Okay.
I'm hopeful we can resolve this either way, but.
Right. Okay.
uh,
I can give you a bench on that day. I think I can I think we could even do this with a jury. I'd even venture to say we could even do this jury. Pick a jury, have the jury. Mhm. Now,
So do we keep it as a bench or a jury?
well, we can't even keep it as a bench because Mr. Saloon can't waive right now. Mr. Body, what are you thinking about a bench?
I would be fine, Your Honor, with a bench trial, and I'm fine with October, so we're pretty easy about it. We didn't plan on asking for a jury trial anyway, but.
Okay. And Mr. Saluma, I understand the situation you're in. You can't do anything. You need to ask your client. Why don't we set it up for let's set it up for a jury for that day, because you may want a jury, Mr. Saloon.
Yes, Your Honor.
Let's set it up for a jury and let's see if we can do it. If in person is allowed, that's awesome. If it's not, then I think we can do this.
Okay, Your Honor.
But can you has the jury fee been paid in this case, Ms. Aguilar? Nobody's paid a jury fee?
No, Your Honor.
Okay.
No.
If your client doesn't allow a bench, right, then pay the jury fee, Mr. Saloon.
Yes, Your Honor. I'll let him know right now.
Right.
Okay, Judge, then I'll let Becky know to set it for the October 19th, a jury trial.
Jury.
Okay, hang on for a second.
Your notice from Mr. Saloon. Okay.
Yes, Your Honor.
The other question I have, well, no, never mind. Never mind. Okay. Okay. Mr. Body, anything else?
Judge, I had a question, Judge Marwan. And I don't know how you've been doing these, Judge, but so if I prepare the order, do we now just email it to you, or do we drop it off in your box at the courthouse, or how do you prefer?
I don't want any in person. I don't want any in person. What you do is you will prepare it, you circulate it to Mr. Esper. Mr. Esper, you will sign it online. You sign it you sign a DocuSign, Adobe, however you guys decide to sign. You will send it to Becky.
Okay.
PDF Adobe, because that's the only way that I can sign is PDF.
We can do that. Not a problem.
That's fine.
And that's it. And that's how it's done. So nobody has to do any in person. I don't want anybody in person, anything. Everybody stay
Okay.
away. Everybody stay away.
It's the safest way to do it.
That's it. Absolutely. That's what Fauci says. Wash your hands, put your mask on, social distance, and you'll be fine. Fauci said that. Fauci's
That
my
sounds like a good idea, Judge.
Fauci's my hero. Absolutely.
You know, Judge Marwan, this is I actually had a trial set in the New Mexico federal court in May, and I thought because of the middle of the COVID crisis, I said, well, it's not going to go. And there were some temporary orders at the time from that district that they said no trials. But the judge was from out of state, and he was pushing us to go to trial. He said, we're going to do it in person in Las Cruces. We ended up settling it, but he was going to make it happen. And I was afraid for my life at the time. I was like, I don't think we could be in a courtroom with 30 people. And, you know,
I don't blame you. I don't blame you. I don't blame you. They pushed it to September 1. The Texas Supreme Court has said that we can't have jury trials until September 1, but it started off
right.
June, then July, then August 31st, which is September 1. I think they're going to push it back. I don't think we're going to have a jury trial for a long time. So I will pick and choose the cases. Of course, civil are much more easier to handle on Zoom, I think, right? Much
right.
easier. So I'm going to give preference to my civil docket, really. And these cases that are least document intensive are the perfect ones.
Right.
Are the perfect ones to try.
Well, sounds like a good plan. Well, we appreciate it, Judge. Thank you. And we'll get that order to you.
Mr. Body, Mr. Saloom, I'm very proud of you. You guys did awesome sharings, the screen. You guys had some great, you guys showed me some great technical moves. I really appreciate that. You guys have a great day. I think we're good. Anything else? Anything else, Mr. Saloom?
Nothing from the plaintiff at this time, Judge.
Very good. Anything else, Mr. Body?
Nothing else, Your Honor. Hope you guys stay safe.
Everybody stay safe and keep social distance and wear your mask.
Thank
That's
you.
all I have to say.
Thank you, Judge.
Thank you.
Mr. Salazar, be safe out there, sir. Please, Mr. Daniel Salazar.
Okay.
Thank you, sir. Thank you
Thank
for
And please
everybody.
don't forget to email the exhibits.
Email the exhibits, council, to Miss Anita
Oh.
Garza, please. Don't forget.
I'll do that, Your Honor.
We
Yes,
need to keep it to keep a good record. Thank you all. You may be excused. Have a great day. Be safe out there.
thank
I'm
you.
I've
Thank you.
stopped
Okay.
recording, everybody. I'm stopping it anyway.